I'm not sure what welcome is.
There you go. Don't get up. Don't get up. Don't get up. Stand up. Oh, you're right. Get up. I could not welcome you none other way than by the legendary, our own Bob Marley. Because you are a man that has been standing up for the rights of people. And you have been standing up. You have been standing up for them through contracts and arbitration and you name it. So, a brief introduction, Doc, a few Chris's, and then we're going to hit it. Welcome, guys.
Thank you, but I'll tell you this much. My favorite whaler was Peter, not Bob. Peter Tosh.
We have so much great Jamaicans. We have so much great Jamaicans that I'm telling you the list is long.
Yes, long list. But I, for present purposes, I am a senior lecturer in the Faculty of Law at UWI West Indies, Mona, at the Mona campus.
Yes.
And I have had a fortunate history of practice in academia as well, where I'm at as well now. I have been in the public service, including having served as an Attorney General in the British Virgin Islands. I have also, yes, I have worked and lived in quite a few places in the Caribbean. And I have also, in terms of just study and experiences, included here in the Caribbean, in England as well, where I would have done both my postgraduate degrees, both the LLM and the PhD. And I really am just one of those persons, reluctant lawyer. I tell everybody I'm not a lawyer, just happen to be in the field. And I genuinely mean that. I have never dreamt of being a lawyer. Still don't dream of being one, but I am in it. And I teach persons to become lawyers as well. So it's a little ironic at many levels. But what I am, and I'm happy to do law, is that my interest is in the area really of economic development. And I think law is one of the best tools that you can have when you're thinking of building and assisting persons in the area of sustainable economic development. So that really, in a nutshell, is what I'm about.
Okay, and most of this is guided by contracts and the type of contract that we get ourselves in, and how we protect the money.
You're right, you know, and I tell people that every aspect of law, including criminal law and other areas of it, could in fact, if you want to think of it in an analytic frame, be given a contract analysis, some level of contract analysis. But insofar as business activity is concerned, which is what I think you're primarily about, what I like to tell persons is that at the core of business is not so much money. It is law and legal arrangements. And even money that we speak about and all the financial arrangements that we put in. Money is legal fiction. Think of a derivative, think of anything you could think of in the area of banking and finance. It is all about legal arrangements being properly put together. It is true, and in fact, it was that is true, except that finance is required to function because appropriate legal arrangements are put in place for it to happen. And so, and at the core of legal arrangements, I like to tell people, is that idea that you have to manage risks. And it's about dispute management. It's about ensuring that you have appropriate arrangements in place which either minimize or prevent disputes from happening, or in the alternative, ensuring that if and when, as they often do, disputes do arise, then you find a way of dealing with them in the best way possible, with a view to minimizing risk, with a view to minimizing exposure and ultimately liability.
And the type of contracts that businesses or individuals, entrepreneurs kind of get themselves in amongst themselves will determine how good they come out at the end of the day. Because as we say, we make the money. You make the money.
Go ahead, Joe, go ahead.
Yeah, because we believe that if you make the money and you never use the right legal remedies to protect the money, then you're not going to have the money. You're going to spend out all of that money in legal fees. So we want to bring to the Money Matters family tonight how to make sure that you keep back, because we look at financial awareness and money matters, right? So we want to make sure that with all of this, we have the expertise now of Dr. Malcolm to share with us, because only on Money Matters you're going to find Dr. Malcolm on this Monday night. He will be nowhere else. So, all right, I just welcome to some persons here. I'm seeing some names for the first time. I'm sure I'm seeing Nikita 116 for the first time. So I think that is coming from Chris side. So the original Money Matters person, I see you rolling in. So welcome again. Welcome. Yes, Chris. So we want to get the feel of you're standing up for the persons that would hire you and you lecture in the field. So when they said, Doc, I need to get ahead on this thing, and you say, well, let us look on arbitration and stuff like that. Exactly what is the arbitration? Daily Carl, welcome. Welcome.
Well, arbitration is just one method by which you may resolve your disputes. But if we step back a little bit, contracts and business arrangements generally are about risk management.
Okay.
And contracts are in substance tools of commerce which are geared to assist parties in doing three things. And I like to tell people that I live by and I advise people to also adopt an I.A.M strategy. And when I say that, I remember that even the Bible speaks about I am that I am. And yes. I.A.M for me is simple. I mean, if you're in business, really what you want to do, if you consider contracts to be risk management tools, and if you consider business arrangements to be a manner of managing your risks with a view to making profit, then one of the things you want to be able to do is firstly to find a way to effectively identify your risks. And the risks that you're going to identify are going to be risks of a commercial nature and risks also of a legal nature. But importantly enough, at least in my estimation, the risks of a commercial nature very often are trumped by the risks of a legal nature. Because one of the things about business and generally what you can do in terms of contract is that there's a basic legal position that contracts and all business arrangements that you enter into, parties have a fundamental freedom to do whatever they want, subject to applicable law. So if something is deemed to be subject to applicable law, it tells me that to the extent that that what you're doing is non-compliant or failing to comport with legal requirements, then you have a problem. So what you need then to do at the start, as I say, is to understand the I, which is about identification. And to that extent, if you're a business person, I rely on you to tell me what you consider to be your risks. And then I can assist you in finding a way to effectively provide for that. Beyond that identification comes the next thing that you want to be concerned about, which is the A, which is the allocation of risk. Because having identified it, if you're in a contracting arrangement, then there's a basic position where you want to think of allocating risk by reference to who is better or best able, depending on how many parties are in the contract, better able to manage and deal with that risk. And then you get ultimately to the M, which is about putting measures in place that enable you to better manage the risk or mitigate the risk. And if you put that all together and understand that the contract is geared towards doing that, then you will now start to think of how you can flesh that arrangement out with risk in mind. But then we get now to the question that you asked originally about arbitration. Now, in this context of contracts and the business relationships that you're about, as I said, as a matter of normal course, you have problems arising every single day. Disputes are a matter of nature. Whether they're in personal relationships, business relationships, whatever the nature of, teeth and tongue will meet, as we say in Jamaica. So you're always having disputes arising naturally. So what it is that you want to then find an effective way to manage your disputes. Not that you're going to avoid them completely, very often you cannot. But what you want to know is that you do not allow the disputes to boil over in such a way that they undermine and the activities that you're getting into and prevent your achieving the objective.
I take away money out of your pocket, because the longer a dispute stretch, you're either losing money or paying out more money.
But it goes beyond that, you know. I tell people there's something which is even more fundamental than that. I have, for the last 15 plus years, been traveling the world, literally, been all over, been helping people and telling people about this idea of understanding dispute management tools. That is whether you're talking about negotiation, renegotiation, arbitration, mediation, even litigation, and understanding them in a way where you can leverage them in support of sustainable economic development and business activity. And let me give you a good idea what happens here. I generally tell people that they're horses for courses. If you're in the horse racing business and you train a horse for 8 furlongs, don't have it run 16. It is going to break down, it is going to get a nosebleed and probably die. So you train, you understand that you have the right people doing the right thing. Similarly, in the area of dispute management, you have a number of options that are available. We think of it as what we call the ADR, or dispute management, a range of options. And those are options which tell you what you may best do. So what you do if you're in the business of business, if you're in the business of dispute management as lawyers and so on, is that you try to understand what each does and what each does best. And then you look at the particular circumstances that you have to deal with, and then determine which of those will allow you to best manage the circumstances that you have to deal with. But guess is what happens. Think about, as a business person, I'm going to give you a very good and very sharp example for the average business person to understand. One of the things, if you think about a balance sheet, there's a little section there where you think about contingent liabilities, right? And just follow me for the minute. And if it is, you know, at the end of every financial period, your auditors will reach out to the lawyers and other people to find out if there's any pending litigation, pending arbitration. Why are they doing that? Because they need to take care of it in their contingent liabilities if it has not yet been realized, right? Yes. And the moment you have contingent liabilities, think about it as somebody in a financial conflict. What does that do? It impairs your balance sheet. So it means that you have to provide for it, and you have to provide for it. What that means? You have less cash flow to work with. Yes, and if you have less cash flow to work with, what that means? It means that you probably have to borrow more than you need to borrow. And you have to have a lot of idle money sitting down. But if it is that you understand dispute management processes well enough, and you plan well enough for them in terms of the arrangements you enter, what you can then do is that you can bring predictability to your dispute resolution outcomes. And you know that the reason you have to put a lot of these things into contingent liabilities and treat them the way you do is because they're unpredictable. You don't know what the outcome is going to be. But there is a way where you can properly plan and better predict. And the moment you bring certainty to your balance sheet is the moment you have greater access to your cash flow, and the moment you can start reducing your interest rates, charges, and all the other things, and you can do the multiplier effect to realize that dispute management properly dealt with is not just about saving your money in terms of what you can pay in legal fees and so on, but it can be used progressively to allow you to better leverage your balance sheet and therefore reduce your interest charges and a number of other things. So those persons who see it in a very static way are not understanding the nature and the extent to which you can use it as an economic tool.
Yeah, you know, Chris, hold on. Persons, welcome everyone. You might be wondering how Chris, as a lawyer and dispute management specialist practitioner, knows so much, but he's actually a former banker and he's very deep into finance. So yes, we go way back from in the bank. So that is the reason why you can tell you everything right now about the whole business of the money side. And that is the reason why we make sure that Chris is no normal lawyer, right? He's no normal lawyer, because that aspect of your balance sheet and putting away that contingent liability and putting away cash flow unnecessary if you don't know what the contract is or what the contract was or what it's all about, then you're going to lose money. You're going to stifle the business. So we want to make sure that you understand the basic of getting a right contract in that business. as even individuals do, because you can enter a contract as an individual and you lose your shirt because it wasn't drafted properly. Yes, Chris.
Yes, so what I'm saying here is that it is something, and that is again where I say to persons, if you're in business and you're thinking progressively about it and how you can do well in it, in the same way that you get your economists and other persons at the front end when you're designing the products and services that you plan to offer, you really should get appropriate dispute management practitioners at the front end as well, who can help you to design your products and services, not just with a view to drafting a document, but with a view to understanding the nature of what you're doing and how they can use the drafting tools to help you to better manage your cash flow and to better leverage it in the interest of the sustainable development that you want.
The average small and medium-sized business, or even the entrepreneur, are going to say that's a cost. It's too expensive. But you are saying look at it as an investment. Obviously, that's what you are saying.
That is exactly what I'm saying to you, and I'm saying to you that you have to. And let me tell you the context here. The truth is, you draft, except in, and I'm going to make a distinction here. If you go in the construction business and you're doing a construction contract, 99% of construction works have disputes arising on them. Somebody build a beam lean, somebody dig a foundation not deep enough, somebody put in the wrong cement or some such thing. Every construction project, or most of them anyway, will have disputes on them, whether they're big or small. On the other hand, most of your regular commercial contracts, somebody buys some flour, somebody buys some sweetness, somebody buys, most of those go without disputes arising on them, most of them. However, what is common about both is that you can have a single dispute arising, which can put your entire business in bankruptcy, liquidation, whatever you call it. And it can go more. It can send you well below what you started at. So what I tell persons is that yes, it is a cost, but it's an insurance policy. It's like taking out an insurance policy. You take out an insurance policy for 20 years and no hurricane comes and hit you. But you want to ensure that when Gilbert comes, or one like it, you have something in place that can protect you. So it's the same thing. You want to ensure that you treat your insurance policies for the investment reasons they can become. Not just because they're able to help you to save and manage money better, because you can, but they're also because of the ultimate protection they give you. But as I said to you, there is an element. Think about, for example, a business person may come and say, well, drafting a contract is money as spending, or drafting something proper is money as spending. But think about a regular business place which has employees. The chance of you running a business without ever having a dispute with your employees over salaries and other benefits and so on is unlikely if you're running any sizable business, right? But you can have a system in place which makes sure that you have reduction of work stoppages and so on by reference to the types of agreements that you draft. So I'm going to give you a good example again from the construction sector.
Don't move.
In England.
Don't move. Welcome, Amelia. Welcome, Philpott. I am telling you, if you ever before believe that getting a lawyer on the front end of your transaction was a cost, Dr. Malcolm is letting tonight all of us know that it's an investment, and you treat your legal contracts as an investment and not a cost. Bring it to the front end. Don't matter how big or small the business is, you will be charged and priced accordingly by your lawyer. And he's saying this is one of the ways that you can mitigate your disputes, and it's a risk management tool. Yes, Chris.
Yeah, I was saying, going back to the construction sector, and it really gives us some good examples. You have a situation where, on construction projects, one of the worst things you can have are delays. Why you delay? Think about a general construction project. What happens at it? Everybody's borrowing money. The developer borrowing money, the contractor borrowing money, the subcontractor borrowing money, everybody on the project borrowing money. But let us go a little further. When you borrow money from the bank, as a banker, what you know, even if you get a moratorium period, interest still running on the loan, right?
Yes.
So think of a project where you have it now running. and you have a delay in the project because there's work stoppage, what happens? The building can't go up, you can't complete it, you can't rent it, so you can't get no income, but your interest still moving. And you may run the risk that by the time all of those disputes are ended, you have to rebuild, you have to do this, you have to do a number of things. So you now start adding additional things. And it is not unusual. We know the examples. We know the periods back 20 or less years ago when persons started, all sorts of things happened. And by the time they ended a project, they were in debt several times over what they hoped they would have earned out of the project. We know those examples. But let me
Chris, they did not manage the risk process. And you're saying that contract act as your part of your risk mitigation strategy at the beginning. Welcome, Steve, and welcome, Shelly Thunder, all the way from US. So we have some persons from US joining us. Thank you. Yes, Chris.
But what I was getting at is that there are some things which are beyond your control. Interest rate movements and so on are beyond your control. But even that you can plan for by way of contracts. But getting to the point I was making. So let's say you borrow money and the project stalls and you still have interest going on. What is your problem? You have a problem in that your project can't move, but you're still accruing interest even if you're not paying it. But let's say you had a contract in place or a legal arrangement in place that says that even if there is a dispute, you can't stop the work. There is a process of adjudication or something else that you can use to resolve the dispute. But while that resolution is going on, the work must continue. What happens there? You have mitigated that risk of downtime and provide for it. And let me give you the real example of that. In England and in other places, they have introduced statutory adjudication and these other things. Now, when they introduce statutory adjudication in England, the position is that they have provisions, and you can go Malaysia, Singapore, and a number of other places, and they've done. We haven't done it yet in Jamaica, but we have contractual adjudication, not statutory. Now, what they did when they introduced that, they said, look, when a project is going on, it is effectively illegal for you to have work stoppages because we have provided a mechanism by which you can resolve your disputes as the project goes on. And I won't go into the details of that now, except to say this. As a result of those measures have been implemented, the projects have come in in time and on the budget. And the whole idea that you would see buildings going up and stopping halfway, that phenomena has stopped. And I'm saying that this is a product of good legal arrangements being put in place, good lawyering skills being employed, and an understanding of the investment nature of legal arrangements, which properly taken can give you all sorts of benefits.
So Doc, I just want to clarify something. We have seen construction projects down on the North Coast, like for the hotels and workers' strike. You're saying that had they put a simple clause to say work can't stop no matter what dispute you have, would start it out after, the project would have continued?
I'm saying that you can put those in terms of contracted. You can. But in addition, in places like England, Malaysia, and so on, they have gone further. They have actually had statutory adjudication introduced, which allows for construction interim payments effectively. So what they do is that they recognize that at the heart of construction is cash flow. So they have now put measures in place to allow for cash flow to continue, regardless, because there's a recognition that everybody's borrowing. So I'm saying, but again, you can only speak to these things that can only put them in place if you understand them. So that I go back to my initial point. You cannot effectively advise people on management tools if you don't know what the tools are. But the lawyer can understand the tools and can implement them.
I just got wind of a post that you have that might let our whole contractual arrangement even in Jamaica get better, because you are giving some oversights to the powers that be. Is it so?
I don't know.
No, I just a Money Matters firm just let me know that, you know, so I just because what you're saying, this country is really ready for a take off on the legal side as long as we can put these things in, because you're right, it is money matters, and there's a lot of disruption and a lot of money going to waste or a lot thereof because of strike that take place on sites. And a day lost cannot be a day regained. And these are examples of what the entrepreneurs need to be aware of. Because once we are aware of these things, it makes our life and our business easier. And that is what we have 5 more minutes on Money Matters Monday. But this is really what we're trying to get out. So I just need to know that is so, that policy guidance might be coming to let business people can understand that have no fear, because there can be some clause there to keep the business going.
And I would say this much. I think there's commitment, as we have seen it, at national level, to move forward in this way. We have over the last several years, for example, seen a new arbitration act implemented in 2017 that replaced one that was in place since 1900. We know, for example, that there are policy initiatives in play at work to try to implement new mediation legislation and those sorts of things. We know, for example, that Jamaica signed onto the Singapore Convention on Mediation in 2019, and we've seen measures happening, and it's across governments. It's not now being taken on any political side one way or the other. It is just saying that we have seen a commitment on the part of governments with an S at the end, to take us into a new dispensation where we can understand the value of law. And in fact, one of the things that I tell people that I'm happy about, when you drive on Constant Spring Road and you look outside of the office of the Ministry of Justice and other places across Jamaica, you see a big sign up saying mediate rather than litigate, or some such thing, right?
Yes.
And that is a positive measure, because what we're doing is understanding the broad ambit of measures that are available, for people to understand that it's not a one-size-fits-all measure. And there are several things. But before we go, there's one thing I like to tell people, because I think it's true. I tell people all the time that modern commerce and the Industrial Revolution and a lot of the things that we have enjoyed have come about not as a result of economics, but as a result of law. And let me give you a good example, simple one. There's a little case that came about in the 1800s called, and it was Salomon and Salomon, which anybody who has done anything with company law knows about. And in that case, the court decided that the individuals and the company had separate legal personality. What did that mean? It meant that as an individual, you could invest in a company, have it separated from you, and if the company had issues, it would not automatically trace back to you, except in circumstances where you can lift the veil and so on and so forth.
Yeah.
What did that do? As a result of that decision, you then had the capacity for people to expand businesses, to have multilateral companies being established and the rest, multinational and all these things. Prior to that, there was no way any individual could have taken on the liability of a Microsoft or any such thing at all, because you just could not as an individual. And as a banker, you know that. But when you have a company which is separate from you, and you can go to your bed at night knowing that the company, if there's a problem with the company, it is not going to automatically trace you unless you have done something wrong. Then in those circumstances, our freedom to allow the company, through its board of directors, its policies, and all its other arrangements, to now expand and develop. And by that method, we had economies around the world developing out of that mechanism. And that was not economics, it was law that put that in place.
Well, Chris, don't move. Doc, don't move. Because what is interesting right now is everybody is going to go and read up Salomon versus Salomon. And additionally, you are saying, get yourself formulated even into limited liability companies that separate you as a person from the business. And the liabilities are up to that point. Unless you do something criminal, then they come dig down the veil and all of that. So pretty much that's what we are getting. It is good to have limited liability companies because you are separating your liability.
It is, and getting back to where we started, because we're talking contracts. But you realize that all these things, including relationships between directors and officers and everything in company, they're all tied to contracts, right?
Yeah.
Everything is about, so you will have shareholders agreements. You will have all these sorts of things being entered. And the shareholders agreement will say who is entitled to what, how you may sell shares, whether or not people need to get options available to them. All of these things are all tied down to contracts. And what do? You now determine what your ultimate objectives are as a business, what it is that you're hoping to achieve. You determine what the commercial risks are. You try to understand with the assistance of your lawyer what your legal risks are. And then you all pull it together in a series of contractual relationships which are intended to work harmoniously together. And if you do it well, and you manage your liabilities well, you manage your risks well, and you put effective arrangements in place, including for how you're going to deal with disputes, through effective contract arrangements, then you are in a much better position than if you're simply trying to do things at the back end when problems arise. Because very often the lawyers will tell you, when you come at the end, boy, had you come to me 5 years ago, could I help you? Right now, I can't, because the arrangement is so bad that the least I can do is try to see how I can minimize your exposure and the liability that you have already created. Had you come to me, I probably could have helped you to be out of it altogether.
And you take on a risk already. Welcome, Rakisha. Welcome, Venice, the motivator. Yes, Chris. I am sure there are some takeaways in that I must identify, you must allocate the risk. One of the ways of allocating the risk is to have the contracts, understand the contracts, and mitigate the risk also by having limited liability companies. Things are predictable, and the contracts act more like an insurance policy, right? Am I right so far? Money Matters fam. Have you received?
Well, yeah, you're right for purposes of the conversation.
I want to make sure.
The truth is we don't want to overcomplicate it. The truth is contracts are meant to be simple. And I tell people that, look, again, remember I tell you that I'm not a lawyer because that is a great ambition of mine. It isn't. And I genuinely mean that. But my thing, is that there's the basic thing in all this is common sense that tell you that, look, law is there and all the cases that you could read in the world. There are examples to tell you whether or not what you're doing makes sense. So you look at them. Case law really works by way of analogy. It's analogical references. The question is to sit down, try to figure out what you want to do, and try to ensure that you have people who are able to advise you as to best how to do them so as not to run afoul of the law. But in order to do that, your starting point must be to try to get people on board who are able to effectively assist you. And unfortunately, we sometimes go for all manner of things instead of seeking out the horses for the courses, recognizing that we all have our skill sets. And I like to tell people this in a very general way, not just for law, that part of the big problem I have, and a lot of us have, is that we have too many jacks doing what masters should be doing. A jack of all trades is something I don't aspire to be, and I don't encourage anybody to try to be a jack of all trades. Try to find mastery in something, and if you're not able to do something, be kind enough to refer to somebody you know who is better able to do it than you are. Because that way you can get the best coming out and ultimately a better product coming out than if you were to try to do everything yourself and as we say in Jamaica, you bitched up instead of doing it properly.
Well, Chris, let me tell you something. I agree with you 100% because I never tried to build a house, never tried to chop a cane field, but I understand money matters. And you understand the legal side of what you are doing. You're not trying to build houses and parks and be mechanical and all of that. So I understand. And that is true. That is true. That is true. So you want to make sure that contracts are simple. Interestingly, Chris, I look at a business contract about 2 weeks ago. And I am telling you that contract was like 16 pages, right? And we had a little thing, a talk on it, and that contract came down to like 3 pages. So things can be done simple, and the simpler the thing is, it's easier for people like the entrepreneurs to understand, which is less costly for them, I would think. Right?
But I'll say this much, John, and don't get me wrong, simplicity is best, and you want to try to get things simple. But the truth be told is that there are some arrangements which are inherently more complicated than others. Okay. And especially if you're trying to do things which are cross-border, meaning you deal with people in different jurisdictions and they have a number of conflicting legal arrangements that you have to deal with and so on. So I am not trying to say for 1 minute that a contract necessarily has to be 100 pages or 1,000 pages or whatever the number of pages. I'm saying that you have to be careful that you analyze properly what you need. And part of that analysis is a cost management process. Because, for example, get back to dispute management. You spoke about arbitration or so on earlier. The truth is that there are some methods of dispute settlement which are much more expensive than others. So even with arbitration, if I were to choose to agree to a 3-member tribunal in an arbitration, it is going to be inherently more expensive than having a single member tribunal, because you're paying 3 persons instead of 1. So there are things that you have to do, and what you have to do, again, getting back to risk analysis. I remembered when I was in a particular office, a younger lawyer came to me and said, here is something and we've put in an arbitration clause. And my question was, but why have you? He said, but, oh, this is what we always do. And I questioned and I said, okay, fine, let us sit down. What is the likely exposure to liability? Not the value of the contract. What is the likely exposure to liability? And then we got and we say, okay, fine, the likely exposure is $20. And I'm just using a fictitious figure. Yeah. I say, okay, fine. But what I have noted is that you have built in a dispute management clause with $100, which is a $100 clause. But why would you have a likely exposure? And that is where risk benefit comes in, you know, risk analysis. Because if you do a proper risk analysis, you realize that it doesn't make any economic sense to build in a $100 clause where your likely exposure is $20. But some people go out and a lot of things are done by rote. You do it because it is always done and not necessarily because you have taken the risk management. So my position is this: if you understand law and contracting processes as risk management tools, then you take management processes to it. And a management process tells me that I need to understand risk, I need to understand benefit, I need to understand liability, I need to understand all those things. Then try to pull them together and then determine what works best in the circumstances, bearing in mind the capacity of a client to meet cost. All sorts of other factors come into play, and then you're able to devise something. But the truth is that not many of us are prepared or even able sometimes to take that level of analysis to the work. And that is something that I think we need to do more of. And that is why the collaborative way of working, which is to involve people who are accountants and all sorts of people who bring their respective skills. I had a matter, or I've had matters, say, that I've done. Let's say I'm doing a construction matter, for heaven's sake. If you give me complicated engineering, I don't know what to do with it. But I will then go to an engineer and ask them to break something down and help me to understand it. And the moment I understand it, I can then go out and I can work with what they have presented to me. Yeah. But I need to understand that I am not going to transform myself into an engineer overnight simply for a matter. But I need to understand the nature of engineering if I'm going to do an engineering contract and what it is that the specific thing is about. And that is why, again, mastery rather than the jack of all trades matter is so important, because if you take that approach, you can then focus your attention in areas where you can develop specific skills. And experience you can develop in those areas as well, which you can then take to the process for the benefits of those you serve.
Like Chris, Doc, Malcolm, we Money Matters would have to definitely take you for a part 2, because our 30 minutes gone, 10 minutes over. We appreciate it. Only on Money Matters Monday, you will find Dr. Christopher Malcolm joining on our live on Instagram. And as Bob Marley said, get up, stand up. Easier to get up, stand up and put contracts in place and dispute management practitioner over the years. You can find him, you can follow him, you can do just about anything. Read his articles, read his work, and just try and understand about your contracts and how you can mitigate the risk. Don't look at it as a